So this is Troy Doucette from Doucette Gurlingen, Ohio and Florida lawyers. One of the questions we get from time to time are calls to deal with homeowners association dues and foreclosures that have been filed because of them. Homeowner association dues are amounts that are paid over a regular time period to an association for the purpose of upkeeping properties. Generally, when we deal with context of foreclosure, the dues are paid monthly, and they're at least a couple $100 a month. In Florida, with condos, it can be much more. They can be hundreds of dollars a month, even for very small properties, or even over $1,000 a month. In Ohio, your average range is $200 to $400 per month for these. When they get behind, the homeowners association has the right to demand payment, and actually has also the right ultimately to file foreclosure as well. There are very few limitations on homeowners associations to be able to file foreclosure any differently than mortgages or tax debts. They're very difficult to defend unless the fees or the attorney's fees are either inflated or well out of hand. So when we get involved with these kind of cases, at least early on in them, we're going to be making sure that the fees are correct and the numbers are accurate, and that they've crossed their T's and dotted their I's. But ultimately, as the case proceeds, for the most part, they're more challenging than, say, a mortgage foreclosure, where there's a lot of other avenues for us to defend. If your objective is to stop HOA foreclosure, dues foreclosure, the best recommendation that we have for you is to find some kind of payment plan that you can work out with the association to pay them back, so you can avoid a sheriff's sale or an auction, foreclosure auction. You can, if you have a lump sum, and you can just pay the lump sum for whatever reason you missed or got behind on it. If you pay that, you have the right to dismiss the foreclosure right away. But a lot of times people don't have that. Sometimes if they do, it's because maybe the auto pay wasn't set up or got misallocated or what have you, but the money is sitting in an account and it can be redeemed or paid off completely. If the money's not there, you're going to have to get into a voluntary agreement with the board in order to make those payments back. Sometimes the board's open to doing that, and sometimes the board is not. Board personalities come into play. The board has to treat you equally as everybody else in the community, and if you have proof that they haven't been doing that, you might have a defense on that front, so they're not giving you a deal. But if you're very late in the process and the foreclosure is next week, I just got a call where it's next week, or coming up in the immediate future, there's not going to be a whole lot that I would be able to do for you if you're post-judgment. You'd either have to get a voluntary deal done, or you can also look at Chapter 13 or Chapter 7 bankruptcy. Bankruptcy will immediately stop the sale and enable you to resolve the situation through the bankruptcy courts. A 7 will just extinguish extinguish your other debts. Doesn't extinguish the HOA amount due. But the Chapter 13 will force them to put you back on a plan and maybe eliminate some of those junk fees or those late fees that have been accumulated, just so you can pay back the amount that you actually past due, plus get you back on track paying your current dollar figure moving forward. If the sale is coming up in the next few days, and you absolutely want to guarantee it stopped, you're going to have to look at bankruptcy. There's no other guaranteed way. If you have some more time in your prejudgment, definitely give a law firm like mine a call. If the judgment has just gone into place and it was a default, and then it might be possible to reopen the case to give you a little bit more time and a little bit more breathing room to reach a resolution with the other side. But overall, HOA dues that are past due are very difficult. We do get into every so often some situations where the law firm representing the HOA is lying about something. We had a case where one of our clients offered to pay the full amount, and the lawyer for the law firm said that her time for doing that was past. She could no longer redeem. And it was actually untrue. The court had not, and the process had not finalized. And it was here in Ohio, and the confirmation hadn't gone on. So he was lying about it. We ended up filing a Fair Debt Collection Practices Act lawsuit against the law firm. Had a great decision by the court and resolved that favorably for our client who held on to the house. So if you have some kind of malfeasance, or you have the lawyers involved, they're not telling you the truth, might be worthwhile also to contact a lawyer that might be able to help. But outside that, a deal or bankruptcy is the route you're going to have to take. My name again, Troy Doucette. My website, lonelawyer.law. If you're in Ohio or foreclosure, feel free to give us a call. Happy to help. Thank you. We're happy to see how we can help. Thank you. And good luck.